I'll bet you didn't know this about bankruptcy, because nobody does. The definition of fraud in bankruptcy is different than it is in the regular courts. The definition of fraud in a bankruptcy is different because it says you have to have received some sort of exchange. You have to have received something. Money, something of value, service, something. In 11 U.S.C. 523 A2, debt for money, property, services, or an extension, renewal, or refinancing of credit to the extent obtained by false pretenses or fraud. You can be fraud without actually receiving any money, property, services, extension, or renewal of credit in the Superior Court. With my client's permission, I'm able to tell you he was a subcontractor. A general contractor hired him to do some work on a house. The general contractor then wasn't able to finish the job and didn't pay my client. My client put a mechanics lien on the house, and then the homeowner, who was a creditor in the bankruptcy that sued him for fraud in the bankruptcy, had sued the general and the sub in the Superior Court and won a fraud thing for partly because of this mechanics lien. But so this creditor was hurt financially by the mechanics lien, and it turns out that my client didn't actually have a right to put a mechanics lien on the house. Nevertheless, he didn't receive anything. He didn't receive anything at all. Yeah, the creditor was hurt financially, but my client never received anything. So in the bankruptcy court, when we did a new trial on the fraud, my client won because he had never received anything. And that's the main difference between Superior Court and Bankruptcy Court in the definition of fraud.